real information. And if anybody knows who I am, they know that I don't really give gray pieces of information. Either you know the information or you don't, right? Because I always say we're dealing with people's lives. So on Friday, immigration threw this horrible memo at us, and they are claiming that green card applications here in the United States have always been the case. But getting those green card applications approved here in America is a form of discretion, is the main vocabulary word that I want you guys to focus on, because that's the word that's going to come up a lot. And the issue that we're having now is when you have a government that basically wants to find ways, unreasonable ways to get people to leave, then they will come up with these backhanded policies to get people, you know, out of the country. What they're essentially trying to do is they're trying to get people, the three categories that they have named physically is H1, tourist visas, and student visas. Now, that does not mean that the rest of the whole universe of green card applications is not impacted. The primary law in the INA is Section 245. Section 245 oversees all of the green card applications that get approved here in America. And there's only two ways. Either you do it here in America or you do it at the embassy. They have gone ahead and said any green card application under 245 is subject to, here's the key word again, discretionary review by an immigration officer. So they know that they legally cannot cut off the arm of the government that does 485 adjustment applications, because it's illegal. It's already part of the statute. So instead, to circumvent Congress and passing laws and all of that stuff, they created a policy saying it's now going to be discretionary. We're not going to stop it, but we're going to make it discretionary. If we want to approve your case, that's when we will approve it. And if we don't want to approve it, we won't approve it. Okay, so now what are those circumstances in which USCIS will approve the case? And those are what is written in the policy memo, balancing of equities and hardships. Balancing of equities is basically, you know, you're good and you're bad. What's going in your personal life? Are you a good person or are you a criminal? Do you do drugs or do you, an advocate against drugs? Do you have a clean moral history? Do you go to your church or your temple or your masjid? That's balancing of equities. And then there's a balancing of hardship, meaning, do you have a pregnant spouse? Do you have a visa status that you overstayed? And now if you were to leave the country, it would subject you to a 10-year bar. I'll give you an example that we're really concerned about is we have individuals that are here on H1. A lot of our clients are putting in the chat box right now, what happens to H1 candidates? The thing is, this goes retroactively. It's not just going for all cases moving forward, which I wish is what it should be doing. But for anyone that has already filed a 485 application, and for anyone that is looking to file a 485 application, what they're basically saying is, you can file that application, but we're going to decide whether or not we're going to approve it. And if we don't approve it based on balancing of equities and hardship, then you're going to have to go through embassy processing, and you're going to have to go and get a date at the embassy in India and go through processing over there. So the reality is you're actually going to be spending your money on both case types, because what's going to happen is for any spouse-based application, let's presume that you're on an H1 and your spouse is filing for you. You file an I-130, that gets approved. Then the case moves to the National Visa Center, and then it gets moved to the embassy. The National Visa Center is only going to keep the case open for so much time. I think you have up to 3 years. What we would probably recommend clients is seeing what they can do, because you don't want to cancel your options on either side. You could try to balance out the 485 application over here in the United States But if that case gets denied, guys, then remember that can put you out of status. If it puts you out of status, you can't go back to the embassy and process, because the second you leave the country, and if you have accrued unlawful presence in the past, then the second you leave, if you've accrued 6 months of 1 year of unlawful presence in the United States, you're going to have a 3-year bar. And then if you have 1 year, no, sorry, I'm so sorry. 6 months of unlawful presence is a 3-year bar, and 1 year of unlawful presence is a 10-year bar that you're now dealing with. So it's not so simple as, oh, well, let me just try this green card application here in America, and if it doesn't work out, I'll just go to India. All of those bars are still in place that are going to get triggered. Okay. Now, we have some questions here. Let's try to take some of them. Actually, before we go into the case-specific questions, does anybody have a question? You can either unmute yourself and discuss it on basically what the policy memo is saying. Before we get into, how it applies to your H1 or your 485 or parents on B1, B2. Anybody have any questions regarding the policy? Okay, it doesn't.
So I'm a little confused on what the main aspect of this is. Can you explain that in a little detail, if as possible, please?
Sure. So Ruth, the way that it works is immigration is there's a section of the law called 245A. 245 under the INA. The INA is the body of law that governs immigration. And basically, the USCIS has 2 ways somebody can get a green card. You can get a green card either through a 485 application here in the United States, or you can get a green card by processing your case at the embassy in your birth country. Now, the issue that's coming up is immigration is saying, if you are here on a tourist visa, student visa, or an H1, what used to be extremely common is, usually after 3 months of staying here, if let's say, you fell in love, or you met somebody, or your parents filed for you, or what have you, right? You would file that application and immigration would approve your case here in America. You wouldn't have to go back to, I would presume most of our clients are for India, Bangladesh, or Pakistan. You wouldn't have to go back there. Going back to your home country, the problem with that is you're looking, in America, the 485s would be approved in probably, depending on the administration, anywhere between 8 months to 2 years. In Trump 1.0, it was taking almost 2 years for them to get approved. Under Biden, it was about 6 to 8 months, right? So if you go to the embassy, you're looking at the whole overall process to be about 3 years right now. And with the system getting floodgated with all of these new applications, it might be even more for countries like India that have a higher population, countries like China. So by canceling out this 485 application here in America, they're trying to force people to essentially exit and file in India. But by doing that, what they're indirectly really trying to do is create situations where people are subject to 10-year bars because they've already been living here in America for more than 1 year without legal status. And for my friends who are on legal status like H1 or F1 or a tourist visa, the problem for my student visa friends is the second you leave to go to your embassy interview, you'll most likely be in violation of your student visa because you're not going to class unless you're able to secure an interview during your breaks. And if you're not, then you're going to have to take time off and go. If you're on an H1, and the I-140 is being processed, and then you have to go to the embassy for your interview, the problem that I'm most likely going to expect is they might delay your case. Anybody who lives in the H1 world understands that H1 stamping is not that easy. There's very common to have administrative delays. Sometimes those administrative delays can be 1 week. Sometimes it can be 6 months. We don't know. And if you're out of the country waiting on this green card application to get approved, you can't work for your employer, because the contract that you have with USCIS, your employer has with USCIS, is that this H-1B representative is only going to work in the United States. It's not offshore, right? So now, how long will your company hold the job open for you? Sachin, I will take your question if you can put it in the chat, because there's a couple questions ahead of you, unless you have a question regarding the policy and not case specific.
Put it in the chat already, so you can address them.
Perfect. Perfect. Sounds good. So that's kind of, Ruth, did that help answer your question on the kind of like what this policy is trying to attack?
Yeah, perfect. Thank you very much. I appreciate your help.
Of course, of course. So we'll go through the questions we have. Okay. We'll start with Michael A., current client here. Will this affect the people who are already in GC process? Yes. Reports that quietly froze every pending case on April 27th. Okay, so in terms of citizen, I guess I'll work my way backwards, Michael, because the ending questions are a little bit simpler than the beginning questions. The 17 banned countries are still banned, right? So there's no change in that. No processing is going to happen for them. Your other question was USCIS quietly froze every pending case on April 27th. I don't believe that to be true, because I was going to multiple interviews. Just last week, I had, I think, 5 or 6 interviews with immigration officers. Interviews were still moving. Approvals were still moving. In fact, actually, I just received a 485 approval in the mail today. So wow, that client's luck is phenomenal, because that case had been approved last week. But moving forward, Friday, all cases after Friday that are going to be new cases or cases that are left in the system that have not been decided, they will be impacted by this. And what we're basically telling clients to do is, if you've already filed paperwork, there's nothing for you to do. What will likely happen is you'll receive what's called an RFE, a request for evidence. And in that request for evidence, they will cite the memo and ask you for, why should discretionary relief be provided to you? So, but if you're a new applicant, then my suggestion to everybody is you really need to prepare this application with the idea of how this discretionary relief is going to be applied. So we're really telling clients to view this like a hardship waiver. It's not a hardship waiver, it's discretionary, but there has to be some type of, shall I call it, some type of standard that we have to follow. And that standard goes back to what we talked about, equities and hardship being balanced. And so what are those equities and what are those hardships that you are suffering from in your personal life? So that's, Michael, I hope that answers your question. Go ahead. Yeah, go ahead, Michael.
Yes, thank you for that, and thank you for basically putting this together quickly. And the follow-up to those questions was just like, is this actually even legal in the first place, and is this basically okay in the face of the law? I know it's a memo, and it's not necessarily, there's no law behind it, but still, like, they are basically telling staffs and they're telling officers basically what to do, even though they're saying there's no law behind it. But at the same time, the officers are the lawmakers as well, especially in regards to these things. So then my question was like, is this legal? Is there going to be backlash from this? And how drastic is this effect on?
So if you read the policy memo, it's absolutely absurd. I would argue 80% of the case law that they have cited in support of this policy go into 1960s and 1970s. They have a sprinkle of cases, maybe 1 or 2 from the 80s, and they have about 3 cases from 2022 and 2023. The problem is the application of those cases is very different. They've interpreted that case law, in my humble opinion, I'm not a constitutional attorney, but I practice immigration. I believe that the case law from the 60s and the 70s isn't really that relevant based on all of the changes that have happened in the last 50 and 60 years. So that being said, I think the administration is trying to premise this on half-truths. Yes, it is true that 485 approvals in the United States are discretionary. The system was created because there were so many immigrants coming into the country. You know, I'm kind of digressing right now, but there was a time where my business partner, who since passed away, Mr. Dalal, he would tell me he started practicing immigration in 1977. They would go in the morning at 9 a.m. with an I-130 and a 485, and by 1 p.m. they'd have a call back at the interview for an interview with the wife and husband, and their 485 would be approved within 4 hours, 5 hours. That's what the system was created to essentially manage. And now, obviously, since 1977, so much has changed. So my expectation is that this policy will absolutely be challenged in court. I'm presuming that our constitutional rights attorneys were probably on Memorial Day weekend, and we're working through it, and hopefully they'll file something by the end of the week. But yes, the relief in terms of 485s being approved here in the United States is discretionary, but it's also common policy. There's substantiated case law to make sure that this is legitimate in terms of approvability. So I do think it's going to be challenged. I think they're basing it on, half-truths. But, when you have the Supreme Court in your pocket, you're more bold to take liberties. So I'll go to, of course, I'll go to Ruth. Ruth, you said my wife is on H1 and I'm on H4. I have my I-140 approved. Green card file will have to go to, yeah. So Ruth, I think I answered your question. As of right now, I mean, that's what it seems like. You might have to go to India. You could try, or your wife might have to. I would ask her to ask her employer and see if they're willing to file a discretionary relief application for you. There's no form right now. We're expecting that a form might come in. And if a form doesn't come in, it'll just be a packet that we're preparing for our clients. And by the way, if you guys are on H1 or H4 and the employers are not willing to do this or asking for additional compensation, to be fair, we are also asking our clients for additional compensation because this is more work. But if your employer's attorney is not willing to do this, then we can come in as a contractor with your employer and we can take care of it for you. So that there's also that option.
Okay, so what's a discretionary form? Is that basically like my employer would have to say that what type of individual we are, like I am or my wife is?
No, my dear. So what it would be is the USCIS policy memo basically is saying if you want to file for your green card here in America, why? Explain to me why you need to have it filed here in America, because otherwise we need you to go to India or wherever the country of citizenship is, not a country of birth is for your wife. So in
Gotcha, okay.
So they'll have to explain all of the problems that your family would have. And if your wife's employer's attorney isn't willing to do that, then you can always connect with my firm and we can do that for you.
Okay, perfect. And approximately how long would that take, do you think?
For the approving or the decision, specifically what?
Both.
Okay. At this time, we honestly don't have any idea. My guess, just out of experience and seeing how immigration kind of blows up, I'm going to guess that it's going to cause delays of up to at least 1 year in applications.
Initially 1 year.
Gotcha. So my wife would potentially need to stay in India for 1 year if we need to do that?
No, you would stay here in America for an additional, the processing of the I-140 and 485 would be delayed by 1 year because there's so many cases to review, is my guess.
Gotcha.
I guess, right now everything is so hypothetical.
Okay.
Yeah. Okay. The next question is by Shri Sukadia. Filed the U.S. Green Card application for my Canadian husband. By the way, I also want to make a disclaimer. This is an open forum, and a lot of this is attorney-client confidentiality territory. So whatever answers I give to my current clients, I'm not going to go into details because I don't want to break that confidentiality. unless, you know, you give us confirmation. The answers you'll be receiving will pretty much be general. Okay. Let's see. I came to US on a tourist visa and we got married. Yep. Work authorization. Does his pending application allow him to stay in the US legally without leaving? And okay. So the pending application does not allow you to stay here legally in the United States. What it does is it legally stops something called unlawful presence. We were talking about, first of all, Shri, are you here? I don't want to
Yes, I am.
You are.
I am. Yep.
So the way that I explain this to all of my clients is when you file a 485 application, you get popped into a bubble. Okay. You're covered in a bubble and that bubble protects you. And the way that that bubble protects you is it stops unlawful presence from accruing. It doesn't make you legal here in the country. It just says that we're not going to hold this time against this person because we understand that they're here because the law requires them to be here for the 485. Shri, if your husband had gone back to Canada, that 485 application would be deemed abandoned. So he has to stay here if he wants an answer on it. So the protection that you get is that there's no unlawful presence being told. What I had mentioned earlier was if you're here in the United States for more than 6 months and leave, it's a 3-year bar, and more than 1 year, it's a 10-year bar. So that bar is going to be measured from any time before the 485 was filed. Does that make sense?
Okay.
So in conclusion, basically what we're going to expect that's going to happen on your case, you're most likely going to get an RFE. Some of my colleagues actually are saying that one of my colleagues, I should say, already said that they received an RFE for a client, basically discussing this discretionary relief. And that's what we're going to be expecting to happen with all of our clients. So we're putting a checklist together. I think you should be expecting, a letter in the mail and, sorry, not letter in the mail, an email to be sent from client support from either Iman or Sukriti. I'm sure you've been in touch with Sukriti, right?
Yes.
Yeah. So they'll send you some information basically on your last question on how can we strengthen our marriage evidence. That's what will likely happen. That's we'll get an RFE, or if there is no RFE, then what I'm going to do, at least for my case, is I don't know what other attorneys do, but I have a higher level of anxiety and I always want to be ready. I want to make sure my clients are taken care of. So if there's an interview date coming up, then we will prepare a discretionary relief package to take to the interview if there is no RFE. Because my expectation is sometimes all of this is auto-generated from a computer. So we don't always get information right away. But when we go to the interview, then we'll get that RFE. So why waste time is my, point. So look out for that email probably maybe Wednesday, I'm guessing by the end of the day. We're putting it together and it'll have essentially a checklist of documents that you can start getting together and then you can start uploading into DocketWise. So when that RFE or when that interview comes, we'll go ahead and get that ready for you. Because it's not just the evidence, it also needs to be supported with an attorney legal brief. So I always say that the evidence that the clients give to us is just it's a skeleton, right? It's the framework of what everything looks like, but then the attorney brief is the fat and the muscles and the skin, right? The makeup. The attorney legal brief is what puts all of that evidence together and makes it sensible for the officer to review and manage, because otherwise they don't know how the taxes come together with, other letters or anything.
Right.
So
and you just mentioned that you have to go back to the birth country. So does he mean he has to go back to India? Although he's a Canadian citizen?
So is that his birth country? India?
India is the birth country, yes.
So we are getting, we're getting mixed guidance. So honestly, we're not really getting guidance. We're getting confusion. Some, attorneys are saying that it should be the birth country, but if you've received citizenship for another country, in the past, we would just have it scheduled in your citizenship country, right? We'd have it done in Canada, but I can't guarantee it this at that point. You know, we've also done situations where there are students and they're studying, and then, you know, we'll have an interview scheduled in Mexico or Canada or the West Indies because that flight is so much faster and closer for people. It's just, I can't give a definitive yes or no right now because we're waiting guidance ourselves.
Okay. And just last question. It's been already 18 months and there has been no update. Should we be worried about it, or?
So if you go on My USCIS, or if you put into Google, for anybody that's here on the seminar, if you put into Google My USCIS processing times, there's what the government is suggesting as proper processing times. A US citizen marriage-based application right now is taking 5 years.
Oh,
Yeah. So in New Jersey, I'm seeing those cases get approved obviously much faster. Trump hasn't even been here for 5 years, but the problem is that the system is flooded and they don't have enough officers. People are getting scared. They're putting more applications in, right? There's all those deportation cases that now are also having marriage applications. So the system is just flooded. They're trying to do their best, but the problem with why that impacts somebody like you, Shri, is when the processing times were 18 months or 15 months, what we would do as attorneys is we would sue immigration, file a writ of mandamus, and we would say, hey, your processing time was 1 year or 2 years. My client has been waiting so much longer. I want you to take them from the back of the line to the front of the line, and I want this to be a priority. And by doing those lawsuits, we would get those cases approved in 3 months because they require mandatory responses within 2 months by the government because it's a federal level lawsuit. By making the processing times 5 years, they've essentially squashed any ability of us to file those lawsuits in federal court.
oh, okay.
What is that called again? Sorry.
A writ of mandamus. It's a federal level lawsuit against USCIS, DHS, essentially the whole immigration system, saying you have not followed your own processing times. You promised that my client's case was going to get approved in 18 months, 12 months, 14 months, whatever it might be. But my client's been waiting for 3 years now, right? But what they've done to counter those cases, they've just increased it overall to 5 years. So now we would have to wait 5 years before we can file anything against them.
Wow, that's crazy.
Yeah, yeah. Okay, thank you, Shri.
Thank you.
Of course, next message is from Sachin. Sachin is saying, so here are two scenarios. One where the GC application is not submitted at all. Where it is submitted, in both cases, I'm wondering if the memo pertains to discretion and approval or discretion to refer the India route. Oh no, the discretion is 100% for approval here in America. Sachin, are you still with us? Just say a quick hi.
Yeah.
Oh, you're still here. Perfect. So the discretion is definitely for filing the adjustment green card application here in the United States. And how long does the India process typically take? So as of right now, or let's say actually as of Friday, if you would have asked me that question, Sachin, how long do these cases take from the embassy processing? I would have told you somewhere between 2 years, approximately 1.5 to 2 years. But now I'm going to guess it's probably going to be upwards of 3 years or more. Okay. And I see your hand is still up. So do you have a question for me?
No, I'll drop the hand. So I'll just have a follow-up. So people with approved I-140, whenever they file adjustment of status and priority date becomes current, like the whole workflow,
Yeah.
and most of, if I'm not mistaken, most of the employment-based green cards will now have interviews. So those interviews will take place here, or for that you have to exit the country and go back to your native place?
So those interviews would be for a 485, right?
I believe so. Yeah.
Yeah. So theoretically, 485s would now only happen with the discretionary relief.
Okay.
So then the idea is that if your employer doesn't support the RFE with whatever equities and hardships need to be presented to USCIS, then the idea is that, you know, they would probably deny it and you'd have to move with the embassy.
And last, and then we can go to the other person.
Yeah.
Whenever we go the embassy route and you
Yeah.
exit the country physically, you have to stay in the foreign country till it is adjudicated.
Yeah. Yeah.
I see.
Yeah.
So delay is the deadliest form of denial. That's it.
Exactly. You don't have to change the law by just saying, hey, I don't want to do it here, I want to do it there. And you can cut off a whole section of thousands of people that won't get green cards now. It's very underhanded and manipulative, this whole policy.
Thank you.
Of course, of course. Okay, Lokesh, would impact on L1 be the same as H1? So, hi, Lokesh, are you still here with us?
Yes.
You are. Okay, wonderful. So, Lokesh, L1 isn't named on the application. I'm sorry, on the policy memo, but it's still a non-immigrant visa. So my educated guess as of today is going to be yes, L1 will be treated the same as H1.
Okay. Thank
But
you.
I would honestly say, you know, for people that are not our clients, if you want to keep receiving updated information, we send new policy alerts weekly. You can put your email address in the chat. You can privately send it to Ken. Ken, if you want to just say hi so people know that they have to message it to you. I'd rather not have everybody's email address, you know, exposed. But you can send your email address right here privately to Ken, and then we can add you to our policy alert email blasts.
Sure, will do. Thank
so-
you.
DM Legal has social media on Instagram and YouTube, and I've put out two videos on updates. So please watch that as well for the most up-to-date information and live information.
Okay. Thanks much.
Of course. So Qasim, Arif, are you still here? He may have dropped off. If you are here, Qasim, and you're saying hi, we can't hear you. You might be on mute. But essentially what the question was, you know, if you're on asylum, how does this impact the case?
Yes, I'm here.
You're here. Okay, wonderful. So Qasim, it's a little interesting. So the policy memo does make a claim to humanitarian visas. And what that basically means is people like asylum applications. The issue is the asylum application, if it's approved, the government is essentially agreeing that you can't go back to your home country, right? And you can't get your processing done over there. So as of right now, my interpretation is that asylum applications are waived from this policy memo because they have made a notation that humanitarian applications are removed from this category. The only other thing that I can imagine is, let's say if my interpretation is incorrect. So if I don't know what you're a citizen of, Qasim, but let's just pretend you're a citizen of Canada. And so instead of going to Canada for processing because you have an immediate threat of life there, you would then maybe go to Mexico for processing. That's the only workaround that I can think about it. But as of right now, my understanding is that that's not needed. You can proceed on your own 485. Okay?
Yes, thank you very much.
Of course, of course. And I do, again, everybody who's here, you know, this is not, I am an attorney and I am giving you guys information, but this information doesn't create an attorney-client privilege. If you have a law office that you're already working with, I would urge you to really discuss it with them, because maybe there's something about your case that I'm unaware of. Also, this understanding of this policy is changing. right? So this is my understanding of it today, May 26th. If something changes, we'll send out those policy blasts, but that's why it's really important for you to remain engaged with the lawyer, because it's possible you may leave with some information here today that turns out to be untrue because of some policy change, right? And what I would suggest to everybody is, if you're not a client of the firm, leave your email address so we can keep updating you. And if you have your own attorney, please talk to your own attorney and find out kind of what is applicable in your case. So, okay, we'll take the next question, which is, and I'll try to go through, it's already almost 6 o'clock. We have a lot of questions. Wow. Naya Patel. Okay, so the only this only applies for H-1B visitor F1. So we've kind of gone through that, Naya. I won't go through it again, but really, I would argue it opens everybody that's under 245, INA 245 adjustment categories. Next question is, hi ma'am, how about people that came on B1, went to asylum, change of status after 3 years, and then withdraw the asylum, gone through hardship in marriage life, and I applied for, oh boy, that's a very specific case. So, Aru Magam, I apologize, I'm like butchering your name. Narayana Swami, are you here? I'm not sure if he's here, but it sounds like to me, again, it sounds like you need a legal consultation more than a general answer, but it sounds like if you're on WAWA, it's a humanitarian application, so it may or may not be applicable to you. But I would suggest that you reach out to my office. Ken, maybe if we can get his email address, somehow we can reach out to him and then speak to him one-on-one.
Yeah, sure. Ma'am, if you could send me an email at my email address, I did put it here on the chat. That's kennethb@dalalmeta.com. Please send me that email address so we could reach out to you.
Okay. And then we have Mr. Agamdeep Arora. I wanted to ask whether the recent concern, she had a valid tourist visa, traveled to the US multiple times, and most recently entered legally more than 90 days. Do you still consider the case? No. So, Mr. Agamdeep, are you here right now?
Yes, ma'am, I am.
Hi. Okay. So, Agam, I would say that absolutely, this is one of those targeted cases. Your mom's on a B1, B2, and they don't want her to apply for adjustment over here. So if you've already filed in 2025, I would be expecting an RFE to come in. Now, the problem is that your mom has been here for more than, if she's been here for more than 6 months and she leaves the United States, she's now going to be subject to a 3-year bar where she cannot come back. And if she's been here, for more than 1 year, then, she would have a 10-year bar. But then again, actually, she's already filed it, so she's technically in the bubble protection.
Yeah, I was about to ask you that follow-up, but
because she hasn't accrued unlawful presence.
can I ask you a question while you're answering this? Maybe that adds up to the situation. So she's never overstayed, and she's been here, like she came first in 2008. She's had like 16 or 17 trips in US, never overstayed.
Yeah.
When she came in 2025, I had you guys to represent us and file that application. So I'm a current client, basically. My question is, I filed for my mom and dad together. My dad got approved. My mom's still pending. There's never been an overstay, never a condition where she violated her visa terms. Now her case is pending. I get it that the memo is pretty generic and it's broadly applied, but for cases like as straightforward as this, where a US citizen is sponsoring their parents, if a denial or an RFE comes, or a denial based on an RFE comes, isn't that open to be challenged?
Hello.
Because sorry, I just wanted to complete that.
Please.
Isn't that subject to be challenged, and how is she going to be out of status until she gets a response on her current case? Like she should, her out of status should apply the day the denial comes and she stays after that, correct?
So the two things that are going on with your mom. Your mom has not accrued unlawful presence, right? Because theoretically, you filed 90 days after, and
Right.
it was probably here. Her I-94 was probably for 6 months.
Correct.
Also, I'm discussing your mom's case. Do you give consent to discuss this in a public setting?
I absolutely do. Yep.
Ms.
You
Mehta,
are
you're
on
on mute.
I cannot hear you, ma'am. I think I completely lost you. You're mute, I think.
Oh, that was odd. I didn't even do anything. Okay. So essentially what would happen is there are two things going very quickly. I'll go through it. Your mom does not have unlawful presence, but your mom she's in violation of her tourist visa.
Not until, so again, I was told by Vishal, the paralegal who's representing me, that the day I apply for her for 485, her tourist visa gets paused and her new application starts, which is the 485 processing. So now when the worst case scenario, 485 gets us an RFE or an interview, or let's say a denial, blanket denial, how can she be how can she be breaching her terms of tourist visa when she actually applied for a 485 within her I-94 time period?
It's a legal fiction that operates hand in hand. Traditionally, and when I say traditionally, like literally for the last 60 years, right? This has never been an issue. You would come here, parents would come here, or spouses would come here, you would wait 90 days, and then we knew that you were in violation of your tourist visa because a tourist visa says you got to go home on the I-94 date. That still stands. That doesn't change. But that bubble that I was talking about that protects you from that violation of the tourist visa is the filing of the 485.
Correct.
So the 485, as long as the 485 would be approved, regardless of the tourist visa violation, mom and dad would still get a green card. That's why your dad has a green card. What Trump is saying now is, that's fine, but I'm not going to make it blanket for everybody.
Correct. Yeah.
And so now we have a new class of individuals who have relied, and this is where this policy is so malevolent, because you can do this moving forward so people can make a decision about their life, right? But Agam, people like you have changed routes and changed how your family is going to operate and move, and you've brought your elderly mom here to stay and live with you on the reliance of this 60-year-old policy that the government isn't going to punish my mom for violating its I-94 because I'm going to make sure I file that 485 in time. Trump is now saying, sorry, I don't feel like doing that anymore. That's
yeah. I mean, yeah. I there's no denial. I don't understand that, man. But I'm trying to see how this memo applies in my mom's situation. Like, how is her case? And I'm trying to be more generic. I'm trying not to give more details about my case. But
yeah.
But when there's been no violation that has happened, there's been no like.
But there is a violation, Agam. The violation is that there was an I-94 time frame that your mom had to go back on. Your mom didn't go back on that. And your mom didn't go back because she had a 485 pending. And if your mom left the country, the 485 would be deemed abandoned. So the government knows that. And the government would normally say, that's okay. I know you violated the terms of the I-94 when you entered, but I get it that you have to wait for this 485. So I'm not going to punish you. Now they are going to punish us.
Okay. I just have one last question, and I'm probably going to give the floor for someone else.
Yep.
So in this situation, for anyone,
I did. I already sent it.
Oh, Ken, you're on. You're not on mute, my dear. Yeah.
sorry, yeah. So I just wanted to ask. So in this situation where the I-94 status stays valid if 485 is being processed, but you become
I-94 never stays valid. I-94
No, I
expires
mean,
before
yeah,
it's
yeah, sorry. I meant like you're still in legal status until your 485 is being processed, but as soon as it is denied, you kind
You're
of are violating your.
status. No. I'll go back to what I said earlier. You're not in legal status. It just stops unlawful presence from.
Correct. Yeah. Yeah. I'm just trying to be more. Again, you're an attorney. You know better words than I do.
I just
But-
want to make sure because the thing is sometimes clients are saying one thing but they mean one thing, and sometimes
Correct.
they're saying one thing and they mean that thing. So I don't.
Absolutely.
That's
Yeah,
all.
yeah, that's correct. So what I'm trying to imply is,
Yeah.
if someone applies for 485 while they're I-94 they're within their I-94 status,
Yeah.
they are still not violating their legal terms. They're kind of in a bucket or blanket period until the 485 decision is made.
Yeah.
Now, if 485 decision is not being made in 6 months, which is the I-94 time period for tourist visas,
Yep.
it doesn't make any sense for any future clients to even apply for 485 while they're on a tourist visa. Is that accurate?
Absolutely.
So there's no point of applying for a 485 if you're in the US, like with a lawyer or without a lawyer. Like, it doesn't really make any sense to apply. Then you have to just go back to your country and apply with the same condition, correct?
Yes. Now here's where the discretionary relief analysis comes in. There are situations where, for example, I have a client who their father passed away and their mom has stage 4 cancer. She can't let her stay in India. Her mom doesn't want treatment, but her mom wants to spend the rest of whatever life she has with her family. So she's here in America. And essentially what we would do when the RFE comes in, we would explain the hardship factors. We know that mom is in violation of the tourist visa. She overstayed her I-94, even though the 485 was filed, all of that. But immigration is going to come back and say, okay, but what's your hardship? Why should I move forward with this interview? And then at that time, our responsibility as attorneys is to then argue the whole point of this memo, that hardship analysis, that discretionary analysis that they've put forward. If based on that discretionary analysis, the application gets approved, the application to file the 485 in America gets approved, then that client can move forward with the 485 here. If that discretionary relief gets denied, then yes, mom has to go back to India. But if she goes back to India, now the problem is that we have to do a analysis of the unlawful presence. How much has she accrued and how much doesn't she have for that bar?
Got it. Yep. Thank you so much, ma'am. That was helpful.
Okay, good. And listen, if you do have more questions, tell Vishal that you spoke to me today at the webinar, and I'm happy to do a one-on-one discussion with you as well.
Appreciate it, ma'am. Thank you.
It might be some time.
That's
There's a lot, but I'm happy to speak to you, Agam. Okay.
awesome. Thanks, ma'am.
Of course. So the next question is from Nandini Kapure for SIJ applications. Rules still okay. So Nandini, if you're still here, my understanding is going to be that again, SIJ applications, I-360s fall under 245, INA 245, and if it's under 245 adjustment, then anything is open. It's open season for them to go out. Why I'm not 100% sure on this right now is because this is where the understanding differs among the immigration community with lawyers. Technically, a guardianship application is a humanitarian relief application. And as I mentioned before with WAWA, the humanitarian relief description in the memo basically says, hey, you know, if you fall into this category, you may not be subject to this discretionary relief review. So as of right now, I don't have a complete answer for you, Nandini, but I'm going to say that it should not be subject to it. But if something changes, please look out for emails and we will be letting you know as soon as we can. Okay? Thank you. The next, oh, good. You were here. Perfect. Mr. Parag Shah, this question is from you. My son came with me and my wife in 2008, and he has been here. He's now 23, and he was on H4. Go on F1 because aging out. So, Parag Shah, are you still here? I don't know if he's here, but if anybody,
Yeah.
you're here. Okay. So, for you, Mr. Parag, basically, I don't see anything in your paperwork. I'm sorry, anything in your question that says that you're a green card application. So you're on F1. So normal F1 rules apply to you. When that time comes, if you were to ever file a 485, then you may have to be a little worried. But as of right now, you don't have anything to be worried if you're on legal F1 status and going to school and following all of the rules. Okay.
Yeah, this is for my son, but for my parents, they have so my mom's on H1 and my dad's on H4, and then they're going to be getting a green card hopefully soon in July 2015. So I was just wondering, am I going to also be able to get a green card since I already aged out? And since I had a file out because I aged out on 21, that's why.
Right. So you're on F1 right now, right?
I'm on F1, correct? Because
Right.
I had to age out from my parents' file.
Sure. So when your parents get their green card, you won't be able to get adjusted right away. I mean, it's still going to be the same thing. Your parents will file the I-130 for you. It'll get approved. And then you can file the 485, but you'll have that discretionary relief analysis if you have to go to India or if you have to process that application here. And right now, I think green card applications for children that are over 21, I think it's like 12 years or 14 years.
Oh, man.
Yeah, I mean, I'm happy. I can look at the visa bulletin right now. I could be making it up. Visa bulletin, what are we in May 2026? May 2026. Let's do this.
But it's not going to affect like the OPT for I-20, right?
No.
Okay, cool.
No, because this is all separate. It's all only for 485 applications. So unmarried sons and daughters of permanent residents, 21 years older, F2B, and you're born in India, Ruth?
Yeah, I was born in India, and we came to America in 2008. And
So right now they're processing for F2B January 1, 2018. So, I mean, do with that information what you will, but it's 2026 and 2018 is processing, and it's kind of, I mean, I've had one client that's been waiting for almost 12 years. So maybe
no, the only thing that I was like mainly trying to ask is like, even if my parents do get their green card, I won't be able to get it because I've been with them since 2008. But since I aged out, I had to move to F1. Does that make sense?
But if you were with your parents on an H4 legally, you never were here illegally.
I was never here. No, never.
Yeah.
Since I aged out, I had to switch over to F1 and get my education. That's why.
And you're still here legally on an F1.
Correct. I'm going to do my OPT, and then I got my master's next year as well.
And as long as you don't break your status, you could technically, your parents can file for you, and then it would just you'd have to wait like the 8 or 10 years though. So then you have to find a way to stay in legal status for 8 to 10 years.
Oh, gotcha. So there's no way for my parents. So when my parents get a green card, I still can't get at the same time because I aged out.
Yeah.
Oh, come on. Okay.
They can try to do, again, I'm not your attorney.
Right.
You reach out to us and see if there's a CSPA calculation that fits into this. I
don't believe it's gonna work. It's only been like 6 months. I try to do the calculation, I believe, and it's like 6 months because we did premium processing for each one.
Okay. So I mean, we're here if you want us to take a look into it.
Yeah, for sure.
We have attorneys on our team that used to work at the embassies as well. We can take a look at it, but as of right now, again, there's no attorney-client privilege here or relationship being built, but it doesn't seem like it.
Yeah, I understand.
But if you want me to do something more, we can, of course.
I could email Ken. That's fine. Totally fine. Thank you.
Of course. Take care. Okay, by Mr. Jay Patel. Saurabh Jain, your camera is on. I don't know if you want to leave it on. You can turn it off as well. For Mr. Jay Patel, if someone is on F1 and the spouse is a permanent resident waiting for AOS, is PR. I'm waiting for AOS. FYI, filed on November 24. Okay, so Mr. Jay Patel, we're not here to really do deep analysis into questions. As a general answer, if you are going to be subject to adjustment of status, you're going to have to deal with the discretionary relief. If the discretionary relief isn't given to you, then you're going to have to process your case at the embassy. If you'd like to get some more information, if you're still here, we're happy to do a paid consultation. All consultations, by the way, are paid consultations with our firm. But, you know, just kind of what you're telling is like very detailed. For Mr. Paraksha, if I get a green card, will he get one too, or will he have to do? Oh, okay, yeah. So we answered your question. You were right before that. Oh, and then it, oh no, Mr. Vikrant said, I submitted my medical and supplement J. Still concerning. I'm gonna, Vikrant, if you're still here, I don't know if you are. My guess is going to be yes. EB1s have not been listed in the policy memo. However, an EB1 is still a 485 adjustment under INA 245. So without additional guidance on whether or not EB1s completely are or are not, I'm going to err on the side of caution and say to you that yes, this may impact you. But, you know, I'm sure you're working with another lawyer. Talk to your attorney's office. If you want to do a consultation with us, then we can look deeper into this. But as of right now, my answer is if it's a 245 adjustment, this discretionary relief is going to be applying to that. Arumagam. Right. Okay. So Mr. Arugamam Narayanasamy, you're my client. Wonderful. Thank you. I don't know if, are you still here? Because I think you logged off and then you came back. Ken, why don't we do this for him? Why don't we just take down his information? We can find his case on DocketWise and we can have Sukriti reach out to him tomorrow.
Sure, Ms. Mehta. Oh, by the way, for everyone, I did pin our Instagram account, so you could send us a message there, and also my email address.
Wonderful. Please follow us, irrespective of whether you follow me or not. But the benefit of that is that's where we're really going to be posting all of the fresh information as it's coming. Social media is really the best way to keep in touch with our clients face to face. Okay, and then the last question is, I have an international travel plan. Do you advise going ahead with travel plan as per memo? So advanced parole isn't impacted in this. D. Manjuluri, are you here, D. Manjuluri? I don't know, he may have logged off. But if anybody watches the recording later on, I can't answer that question because I'm a very conservative attorney. I don't like to just freely say to clients, oh yes, you can go here or can't go there. If your status is not established, then I would always recommend on the side of caution, don't travel. But if you are our client, please do reach out to us and then we can discuss with you. Ken, again, maybe for this client as well, or I don't know if he's a client or not. Let's find out if we are his attorneys and we can have Sukriti reach out to him.
Copy, Ms. Mehta.
Okay. All right. Thank you, everybody. I hope this was helpful. I know this is, oh, Shreya.
Oh,
so, okay, go ahead. Go ahead and ask your question, my dear.
Hi, I just texted in the group that I have asylum pending going on, and
Okay, sorry.
I'm sorry.
Yeah, go ahead. Yep.
Yeah, and I'm about to apply adjustment of status with my spouse. I wanted to know that my asylum is pending. So is it gonna affect, like the new memo is gonna affect us or no?
Yeah. So Shri, I'm not your Shreya, I'm not your attorney. This isn't attorney-client privilege, and I could also be wrong because the has only been released for, if you consider business working days, only 48 hours. So there's very little guidance. My understanding as of May 26th, 6:10 p.m. Eastern time, is that asylum applications, I don't think apply in this. If you read the policy memo makes an exception for humanitarian applications. Asylum is considered a humanitarian application. So I see one of two things happening, Shreya. Either they're going to make an exception for people like you on asylums, and we have clients as well that are in this boat too, right? So we're still figuring it out. Either the exception will prevail and you'll just be able to file your 485 here, normal, no problem, no other issue, and life moves on. Or the alternative will be, sometimes what happens, Shreya, is maybe you can't go back to your home country for stamping, but they may ask you, so let's say if you're a citizen of Canada and you can't go to Canada for stamping because you fear death by going back there, then basically what you would say is, I will go to Mexico. So some other safe third-party country. But again, as of right now, my understanding is that the memo makes an exception for humanitarian applications. But if my understanding changes, I'll be the first person to post on social media and let everybody know. Because again, all of this is developing information. Okay?
Got it. Thank you so much.
You're welcome. Okay. So if there's no other questions from the group, I'm really glad that everybody turned up. I know there's a lot of confusion, and instead of ChatGPTing it or, asking your friends, which I know creates a big problem, I hope this gave you some understanding. And we host these. So normally we do these on Wednesdays, but I host an open public Google webinar, a town hall, essentially, every Wednesday at 5:30 p.m. So stay focused on our social media. We give you the updated link every time. And any questions you have, whether you're a client or you're not our client, it's an open forum just like this, and I'm happy to answer them. Okay. Thank you, everybody. It was lovely talking with you. Speak to you soon.
Thank you.
Thank you. Bye-bye.
Thank you.
Bye.
Thank you. Bye.